My name is John Klein. I'm a lawyer in San Francisco. I'm going to introduce my fellow panelists here in a minute, but this is a little bit of a setup panel. We're going to touch on some topics that other panels will explore in more detail later in the day, but we want to define the problem, discuss it a little bit from the business perspective, from the perspective of individuals who are charged, and begin to highlight some of the key issues. So let me start by identifying my fellow panelists here. To my immediate right is Kate Todd. Kate is the Senior Vice President and Chief Counsel of the U.S. Chamber Litigation Center. To her right is Reg Brown. Reg is a partner and chair of the Financial Institutions Group at Wilmer Cutler, Pickering, Hale, and Dorr. To Reg's right is John Lauro, who I first met some 20 years ago when we were both much younger and less experienced. John is the principal at the Lauro Law Firm in Tampa, right, John? And New York. Tampa and New York, a multi-city law firm. I'm from San Francisco, by the way, so we sort of span the country here. So I'd like to start by defining the problem that we're going to spend the day discussing. What is over-criminalization? We bandy the term about, but what does it mean? And the definition that I found that seems to me to cover the problem best comes from the Heritage Foundation. I figure, as a criminal defense lawyer, how can I go wrong citing the Heritage Foundation? So the definition is as follows. It is the trend to use the criminal law rather than the civil law to solve every problem, to punish every mistake, and to compel compliance with regulatory objectives. I think that pretty well sums it up. So what are the symptoms or the characteristics of what we are calling over-criminalization? Well, we've heard some of them talked about this morning by Chairman Goodlatte, by Norm Reamer. Broad, vaguely worded criminal statutes. That's probably the chief characteristic. You have conspiracy to defraud the United States. You have the mail fraud statute and the wire fraud statute. And these are statutes that are so broadly worded that creative prosecutors can fit almost any distasteful conduct into them and create a crime from them. You have regulatory crimes. You heard Chairman Goodlatte talk about, I forget the number, but it was staggering, 300,000 regulations that the violation of which can subject a person to federal criminal liability. You have prohibited conduct that is not inherently wrongful. Some things we all know are wrong. It will come as no mystery that murder, for example, is going to be a criminal act. It's going to be subject to criminal sanction. But how about certain record-keeping violations? How about taking a fish that's longer than a certain number of inches? I mean, there's a whole plethora of regulatory and even statutory offenses that one would not know are even potentially wrong, much less criminal. Reduced mens rea. There are a number of criminal statutes that have little mens rea. It might be negligence, it might be recklessness, it might be no mens rea at all. I know Kate has filed an amicus brief, or her organization has, in a case called U.S. versus DeCoster from the 8th Circuit, which tests the so-called responsible corporate officer doctrine, where a regulatory violation within a corporate officer's sphere of responsibility can subject him or her to criminal liability, and at least if DeCoster stands, to imprisonment with no mens rea at all. No negligence, no knowledge, no intent, no nothing, except you happen to be the person responsible for that part of the operations of the company. Another characteristic, I would say, of over-criminalization is punishment, draconian potential punishment. This, in the federal system, has been in the past a function of the federal criminal, the sentencing guidelines, which in fraud cases at least are pegged to loss, actual or intended. Of course, the guidelines are no longer mandatory, but they still exert a very heavy influence. And on top of potential prison sentences, which of course are important to individuals, you have forfeiture, which can produce just staggering numbers, millions of dollars that really are, in a sense, fantasy numbers. They're imposed on individuals and companies that can never begin to pay the amount imposed. But of course, it's like a lifetime ball and chain for the person or the company who is tagged. You have enormous fines. Sometimes you have restitution figures that are completely out of line with the actual harm done. So those are what I would call the main symptoms or characteristics of over-criminalization. This is, I would say, primarily a federal problem, although as Reg will talk about in a bit, the states are getting in on the act, some states at least. And I would say that all three branches of the federal government bear responsibility for what's happened. Congress, of course, and I was glad to hear Chairman Goodlatte pave the way for me to say this. Congress tends to react to almost any serious problem, whether it's the savings and loan crisis or the Enron collapse, with a slew of new federal criminal statutes. Of course, those federal criminal statutes overlap with the broad statutes that already exist. The result is you have the potential for a single course of conduct to be charged under a number of different statutes and a number of counts, which obviously allows juries the opportunity to compromise and to find somebody guilty, thinking perhaps they're doing the defendant a favor, when really they're just making the person or the company into a felon. So Congress has certainly had its share of responsibility. I would also cite mandatory minimum sentences and otherwise harsh sentences as something that is Congress's responsibility. Federal prosecutors, the executive branch, it's like the hammer seeing everything as a nail. Federal prosecutors tend to see every social problem as a potential criminal case. And because they have these broadly worded federal statutes, and because they have other investigative tools that enable federal prosecution, you see a vast overuse by the executive branch of the criminal sanction, as opposed to, for example, civil sanctions or administrative sanctions. The default position seems to be to go criminal. And then there's the judiciary, which of course is sort of particularly for individuals, for criminal defendants of any kind, it's the backstop. It's supposed to be the independent, objective protector against this sort of overreach. But all too often we see federal judges indulging prosecutors' creative interpretation of criminal statutes. We even see the federal courts making up criminal offenses on their own. Insider trading, for example, is largely a judicial creation. The doctrine of willful blindness, which is one way that mens rea has been watered down over the years, is entirely a judicial creation. The Pinkerton doctrine, under which a person who is part of a conspiracy can be found guilty of substantive offenses committed by other conspirators without any intent to commit them at all, is entirely a judicial creation. And in other respects as well, the judiciary has not always lived up to its responsibility to police both the constitutionality and the use of federal criminal statutes. So that is kind of a quick tour from my perspective as a criminal defense lawyer of the problem that we're dealing with, the definition, the symptoms, and in a general sense, the responsibility. So with that, let me turn first to Kate from a business policy perspective, working at the chamber, and ask you, how do you see this problem?
Kate, do you want to go to the bar now that he's laid out how horrible the problem is?
No, I should start by saying yes. I am here, bringing the perspective of the U.S. Chamber, but I should confess, I'm Catholic, that's what I do, that my earliest brush with over-criminalization was as a very young child, the daughter of a small-town firefighter who was told he could no longer wear Smokey the Bear, which has already been referenced by Chairman Goodlatte, that he could no longer be Smokey the Bear when he talked about fire prevention.
But now he can.
Well, he then had to become Fire Pup, which, no offense to Fire Pup and the company that promotes it, but was kind of lame. So That was my first brush. But from the business community's perspective, I mean, I think you have a lot going on, including at the very top line of a narrative out there that is sort of trying to paint a picture that all businesses have a room full of lawyers poring over the US code, figuring out not just what loopholes there may be, but what they could violate and get away with. And that is just, aside from being absurd, not at all consistent with what we're seeing from the business community and the frustration from the business community that their desire is to know what the rules of the road are. And that's even putting aside the desire to be part of the process that helps develop those rules and making sure that they're properly calibrated to promote all of the ends that we need to promote in a criminal justice system, but that they don't know what the rules of the road are. They'd like to. They want to be able to put their business plans in place, their plans for compliance in place, and still have some breathing room for innovation and growth. And that sort of simple need to just know what the rules of the road are is harder and harder in the over-regulatory environment. And again, it was already mentioned when the chairman opened, the sheer number. So you're not talking about just poring over the US code with more than 4,500 different ways to reach criminal penalty, but the more than 300,000. And I mean, it's somewhat absurd that we even have to estimate the numbers because no one can quite get their arms around all of the forms of criminal liability and criminal exposure. But so that's why I think we're often in this space trying to figure out what the right metaphor is. I think maze is good. I'd say it's more of a maze with shifting walls and landmines in it for purposes of the business community trying to figure out what they need to do. And I think you did a great job of sort of laying out different forms in which over-criminalization presents itself. And I just put hone in for a second for those of you potentially new to the topic. How do businesses themselves get tagged with criminal liability? Just the very basic proposition, right? And that is both as an entity, they can have direct criminal liability exposure through the operation of its agents. So we've imported over time civil notions of agency into the criminal realm, actually expanded it in some situations and sort of made it looser than it would otherwise be in the civil context, so that you've come to a point where you can have business entities that are themselves held criminally liable for the conduct of a low-level employee who may or may not have been acting in the interest of the company. So that's sort of one layer. And then you have the much more obvious that we all know layers of the individuals being able to be tagged with criminal liability for their particular conduct, but then also that tier in between that you referenced with strict liability crimes, which is the responsible corporate officer doctrine, which is what you'd already mentioned in the DeCoster case, where you can have individuals with some sort of supervisory capacity that are ultimately held liable criminally, individually, and potentially with imprisonment if the government has its way in the Eighth Circuit, for not affirmative acts, but for omissions, and omissions that may have involved no intent and no knowledge. And so those different layers and tiers of exposure and liability, all, by the way, that are part of a broader picture of over-enforcement and other coercive tools, can create some real tensions, pressures, and problems that I'm sure my co-panelists can speak to, and the Yates memo brings up, which I know is a topic for conversation later in the day, but that it can create some real pressure points because of those layers and potential conflict and tensions of employees versus supervisors versus the companies. So we're consistently hearing it's a major problem, and companies just need to know what they can do to get it right.
Kate, years ago I represented a bank at which a number of low-level employees fairly clearly violated the law. There was no evidence that upper-level management knew about this, and in fact, the conduct of the employees was completely contrary to the bank's compliance program, to all the training that the employees were given. In effect, what the employees had been doing was taking shortcuts to really to save themselves the effort of doing their jobs. But the fact that the bank had a compliance program which prohibited the employee's conduct was no defense at all. I'm not even sure it was admissible in evidence at the bank's trial. Is that still the way things look? Can a company insulate itself from liability in any way?
They can certainly take steps to help, but no, they can't completely insulate themselves from that liability. And I think this is a topic that both the U.S. Chamber has filed on in prior cases and in combination with NACDL. So no, there's still exposure, and I don't know if my co-panelists want to speak to that. But
So let me ask you this, again, from sort of a policy perspective. The business community has been pretty effective in fighting back when it feels like its interests are being put under assault. Take the class action setting, it's been quite effective. Why has there been so little success, or maybe even effort, by the business community to deal with this problem of over-criminalization?
I'm hesitant to say there hasn't been, certainly real focus and real energy. But I think that much like many topics on the civil side, certainly from where I sit, when we're not suing the government affirmatively over some of this over-regulation, we're filing amicus briefs in important topics. And when we sit across the table from businesses and members, we look at two different things. We'll say, what are your issues? And then usually what follows from that is, are there cases we can touch? Are there things that we can get into on that? That's because, from my vantage point, it's getting into the cases. And Lisa and the Institute for Legal Reform does such a great job of taking it to the hill. But on the honing in on the cases, there's a mismatch between those two. And we saw it, I would say, 5 years ago, one of the top of mind items that got listed by every company I talked to was False Claims Act, for example, on the civil side. And they would say, terrible problem, terrible problem. I said, great, show me a case I can file in. Nothing. And I think for a variety of reasons, including that the costs of pushing and losing were so high, people weren't going forward. Those issues weren't presenting themselves in a nice, pure, legal way at an appellate stage that people could really bite into. I think that's changed. And there have been some companies that have been really willing to push the issue. We've had the Supreme Court touch on it, and a lot of issues are developing. I think the Alien Tort Statute context is another one where it has not always been a favorite to run into a case that has some horrific human rights abuses alleged, obviously very tenuous from the corporate defendants, but again, the business community has made tremendous strides in helping support those who are willing to move forward and pushing that issue. And I think that that's what needs to be done with respect to the over-criminalization problem. We need to figure out how to move from the issue to the cases, find those cases and be flexible to maybe get to them a little bit earlier in the process, and be willing to probably go into some cases where there are very bad facts. We all know the adage, bad facts make bad law, but that's the space where perhaps the business community and other organizations that are focused on this issue can do the best job of going in and trying to sort of separate out what may be a desire to get to really what looks like very bad conduct, but doing it through rules that are way too loose and will sweep in a lot of other folks. So we've just give you an example, recently filed in an off-label marketing case, criminal case in federal district court in support of a motion to dismiss the indictment. And we came in and brought what everyone knows are some pretty obvious First Amendment arguments. Didn't get the indictment dismissed, but I think really helped shape for the judge the way to think about what the standard should be in trying to get to the individuals in that particular case. And I think also it's about coalition building and getting the right groups together to come in and push the message in a positive way, but really having to be creative about finding those cases and being willing to step forward.
John, I agree with Kate, but I think you'd probably also agree that if we are just dealing with this when we get to the case stage, we're never going to solve the problem. It's an optics issue. Business doesn't want to be involved in it. If the sentence starts with criminalization, you don't want your company to be associated with the term. I think there's still a long way to go just to convince people that there is a problem here and to explain how it is a drag on the economy, and how over-criminalization sort of hurts sort of good actors and the ability of folks to keep the economy moving. It was interesting. I looked at these numbers, and I then went on a Twitter site called Crime a Day, and they've sort of taken it on to identify one of these federal crimes every day on Twitter. And the problem is it's going to take 800 years for them to list all of the crimes, just doing one a day. And I looked at it, and I picked out 3 that were my favorites. The first was, it is a federal crime to let your pet make a noise that scares wildlife in a national park. So if you're walking through a park and you've got your dog, and the dog barks, and that happens to scare a bear, you have committed a crime. It's a crime to skateboard or play a loud radio at the National Institute of Health. And we all know, because we have children, that skateboarding is not a crime. And my favorite is, it is a crime to advertise wine in a manner that suggests that it has intoxicating qualities, as if we didn't know. You know, when you lay it out for people that there are more than 300,000 federal crimes, you can convince them, without sort of being on the side of the criminal, that perhaps that's too many, and maybe we need a base closing and reduction initiative for federal crimes. And so I think there's progress that can be made through terminology changes and engaging people around the real-world implications of all of these regulations and laws.
Well, Reg, let me ask you, you're kind of on the front lines. You're actually advising general counsel of companies when they're confronting the regulatory, the power of the federal government or state government in some instances. How does over-criminalization affect what you do? How do you counsel a general counsel?
Counsel therapy, might be the right way to think about it. Look, I spent a lot of time with large financial institutions who, on the back end of the financial crisis, are dazed and confused. Dazed because they have paid out extraordinary sums of money to address things that were, in many instances, just business mistakes. Where the shareholders already lost a lot of money because people made bad business decisions, and the government's decided that it wanted to criminalize some of those decisions at the corporate level. They're confused because they are spending more on compliance today than at any time in their history. They want to do the right thing, and what the right thing is incredibly nebulous and difficult to articulate. And it is a problem at the federal level, and it is also a problem at the state level increasingly. So you've got this large number of federal crimes, but then you've got state attorney generals that have statutes that have criminal or quasi-criminal characteristics that are incredibly broad. New York, the Martin Act. I found a case that describes the scope of the Martin Act as prohibiting all deceitful practices contrary to common honesty. I'm not quite sure I know what that means. I can't advise my clients, and my clients are having a difficult time understanding the full scope of what it is that is prohibited. They want to do the right thing. They've become more risk averse, and in some respects that's a good thing. In other respects, it can really be damaging to the economy. Anti-money laundering regimes are an area where the government is taking very aggressive action. The easy response, if you have a small operation that perhaps is in some part of Africa or South America and the like, is just to demarket, to de-risk, to get out of the space so you avoid the exposure. Is that the right thing for the economies in those parts of the world? I'm not so sure it is.
We talked a little bit before we got up here about climate change and the criminal investigations into corporate disclosures about the potential effect of climate change. Can you tell us a little bit about that?
Yeah, it's an interesting issue, and I don't want to opine one way or another on the issue of climate change, but it is a bit disturbing to see a policy debate around that topic veering increasingly toward the criminal enforcement lane. We had members of Congress suggest that the Justice Department and the FBI launch investigations under their RICO authority to determine whether or not the research that had been done by energy companies or by think tanks, just focus on that for a second, was in some respect misleading and part of some grand scheme. That veers dangerously close in my mind to thought crime, and that ought to give us all pause. And it's not just, again, at the federal level. I think at the state level, a state attorney general in the Virgin Islands sent out subpoenas to large numbers of institutions wanting to dig into their research going back years and years on that topic. And you got to ask, are we criminalizing policy disputes? And if so, what are the real consequences of that?
In a minute here, I'm going to turn to John Lauro to talk about how all of this affects the representation of individuals, which is what he and I mostly do. But from the business perspective, how does over-criminalization affect the relationship between a company under investigation and individuals at that company who might potentially fall within the scope of the...
So obviously companies operate through individuals. It is having an impact on the relationships internally within institutions. You want to be able to go to your general counsel and ask your general counsel for advice. You want to go to the compliance unit and ask them, how do I do this the right way? When a problem has arisen, you want to be able to go in and say, hey, we made a mistake. How can we correct the mistake and get to a better place? Those things become riskier in an environment where there's a lot of pressure on the institution to identify and give up individuals and to sort of cut them loose and effectively tag them for wrongdoing as the price of allowing the company to move forward. Having said that, I do think businesses are all trying to do the right thing, and they're working through these issues, but it's hard.
Yeah. I am going to turn to John Lauro in 1 second, but before I do, I want to just flag a couple of cases that are pending right now that I think are interesting. What typically happens, or has historically typically happened in my practice, is that when a company is investigated and its officers are investigated, the company works out some sort of a deal with the government and cooperates, not necessarily because it feels it's committed some criminal act, but because that's often the prudent thing to do. The individuals get cut loose and they end up going to trial. So you have a lot of prosecutions of individuals, very few prosecutions of companies. In the Northern District of California, which is my home district, there are now the opposite situation in two really notable cases. One is a prosecution of FedEx, and one is a prosecution of Pacific Gas and Electric. In both of those cases, what I would consider regulatory violations at worst, and I'm not even saying there were violations, regulatory violations at worst are being prosecuted as crimes. No individuals have been charged, and that's because there are no criminally culpable individuals, which should tell you something about the nature of these cases. I should say, in the way of full disclosure, I represent witnesses in both of those cases. So the companies are being charged, no individuals are being charged, and here's the really striking thing. Both companies have chosen to go to trial. Instead of doing what companies have for years found to be sort of the prudent thing to do, which is to work out some sort of a deal with the government, a deferred prosecution agreement, a plea, whatever it is, these two companies have decided to take these cases to trial. And they're actually starting within a day of each other in mid-June, so next month. And it'll be very interesting to see how that turns out. Whether that proves to be a wise move by the companies, and whether maybe it's the harbinger of things to come. Maybe companies will start to fight some of these excessive charging decisions, or of course it could turn out the other way. Both companies get convicted and are subject to huge penalties as a result, but they'll both be interesting. One other case I wanted to highlight, and I didn't know that Kurt Mix was going to be part of the faculty today, but I see that he's here. The BP case, the rising from the Deepwater Horizon. I represented one of the individuals charged in that case. That was a case where the company pled guilty, and I cast no aspersions at all on the company's counsel. It may well have been the wisest thing to do. But the company, BP, pled guilty and paid an enormous fine, billions of dollars. For the lead counts were manslaughter counts based on the conduct of two well site leaders, Bob Kaluza and Don Vidrine. I represented, along with many other lawyers, Kaluza. It turned out later on that the conduct for which BP pled guilty, based on the conduct of Kaluza and Vidrine, the Fifth Circuit later held that wasn't a crime at all. It didn't violate the Siemens manslaughter statute to which BP pled guilty. So what happened in that case is, first there was a tragic accident. There was, in my humble opinion, no criminality at all. But there was, of course, as there always is, a massive criminal investigation that once it geared up, it had to find somebody to charge. And BP, even though it had a good defense, and even though it had an argument that on the individual's behalf later proved successful, that what the government was alleging was manslaughter was not a crime at all. It pled guilty, and of course, even after the Fifth Circuit decided in favor of the individuals, I'm sure BP is not going to be withdrawing its plea, because if it did, it would be subjected to all kinds of other punishment by the government. But it's those sort of opposite poles. BP pleading guilty to something that's not a crime. Per the Fifth Circuit, it is not a crime what BP pled guilty to on the manslaughter counts. At the other end, you've got FedEx and PG&E, who are both going to go to trial and test the government's theories in a court of law. The different approaches there are interesting, and what happens in PG&E and FedEx may well set the tone for what General Counsel will decide to do going forward. So with that, let's pivot to individuals. And again, John Lauro and I have spent our careers mostly defending individuals and not companies. But of course, this over-criminalization problem we're talking about affects the relation between individuals and companies. So why don't you start with that, John? How do you see that affecting your defense of individuals?
Think about a time when somebody accused you of doing something wrong. And in your heart of hearts, you thought, I didn't do anything. And multiply that feeling by 10. And then add on perhaps the worst fear someone could have, which is that someday you might be separated from your family, from your community, from your friends, and put in a place where everything you've worked for your whole life is stripped away. And all the security that you've had is gone. That's what over-criminalization means to me, because I represent individuals that are accused of crimes when they have no idea that they've done anything wrong. I was a federal prosecutor, and I can tell you that using the federal statutes and given enough time and grand jury subpoenas and FBI agents, I could accuse everyone in this room of violating a federal statute. And not just Smokey the Bear statutes, mail fraud, wire fraud, healthcare fraud, securities fraud, bank fraud, tax evasion, you name it. The reality of over-criminalization is that everyone is at risk. And frankly, most business leaders don't think about it because they're not criminals. And they're not focused on criminal law unless criminal law comes knocking on their door. And then life changes in a heartbeat. And I'm not talking about predatory white-collar criminals like Bernie Madoff. I'm talking about ordinary, hardworking entrepreneurs, business leaders, white-collar workers that suddenly find themselves on the other end of a criminal investigation, not because they did anything for their personal benefit, or not because they tried to steal in the conventional sense, but because they were doing their job. There's part of society today that believes that if you're profitable, you're committing a crime. And folks who think that way sit on our juries. And the reality is that today's business environment means that you're facing a vast array of regulations, contracts, statutes, and you have to make judgments. And God forbid you make the wrong judgment and somebody comes after you on the theory that you violated the mail fraud and wire fraud statute. And that's really what we're talking about. To me, it's not speculative. It's not theoretical. It's reality. And the folks that I represent are looking at 15 or 20 years in jail for something that they can't even articulate they did wrong. But the reality of our statutes today is that everybody is at risk.
Okay.
And that's the way I look at it.
Now, a lot of the people you represent, John, are corporate employees or former corporate employees, true?
Well, let's face it. I mean, there's a legitimized extortion racket in the United States right now. Okay. So that, let's say I'm a qui tam lawyer, and somebody comes to me with an interesting False Claims Act case, and I want to make a lot of money on it. I'm politically influential. I make contributions to a lot of political candidates, whomever. And I go to a prosecutor and I say, you know what? This company did something wrong criminally as well. And in fact, the Department of Justice has just announced, we want those qui tam lawyers to come to us and talk to us about criminal targets. So now there's a criminal investigation started. At the same time that it's going to benefit the qui tam relator and the qui tam lawyer, and the qui tam lawyer is making all these nice political contributions. And 200 FBI agents show up. What is the company going to do? You know, there's a wonderful scene in The Godfather. Either your signature or your brains are going to be on that deferred prosecution agreement. That's the reality. And the collateral damage in all of this are the individuals who work at these companies.
And concretely, how does that play out?
Well, okay.
The scenario you've just described occurs, and we've all been through it. The qui tam lawyer or whoever has prompted the government, maybe an article in the newspaper prompts the government. 200 agents come in. The company is reeling. You know, the general counsel hires Reg. Yeah, don't worry, I got that.
And in fairness, Reg wants to save the company.
Reg's client is the company.
I'm looking at what's going on with my stock.
Right, the
It's
stock
dropping
plummets.
dramatically,
And
and I'm getting pressured to move quickly. I do an internal investigation, and perhaps I agree that there hasn't been a crime committed, but maybe somebody got something wrong, and for the good of the company, I may need to let that individual go. I'm going to make sure that he gets a good lawyer in the person of John, but I've got to put the interest of the company first.
Your client, Reg, is the company,
Yep.
and the shareholders, and that's what you have to look out for. Your
Let me put my
client,
prosecutor hat on a second.
your client, John Lauro, is
right.
that individual employee. So how is that employee affected by Reg's decision, a wise one on behalf of the company, to cooperate?
Well, first of all, I tell Reg, you know, I'm not interested in your defense, okay? I'm going to prosecute you, I'm going to prosecute the company unless you give up individuals. And you tell me how I can prosecute individuals. Otherwise, I'm not interested. Take a walk. We're going to prosecute you. You're a public company. You're over as soon as we indict you. Okay? So that's what counsel for the company hears. And they have to factor that in. What that means for me, representing individuals, is they're suddenly targets of a federal investigation where the company has an incredible incentive to do whatever's possible to protect itself and give up the individuals.
And how does that, concretely, what does that mean?
Well, it means that I'm not going to have access to the assistance of the company. I'm not going to be able to get some kind of joint defense with the company. It means I'm left out on my own. It often means that the reality is when that happens to a public company, and Reg knows this, the audit committee takes over and they turn on their former management team to save themselves. And if you're representing former management, you're now isolated. You're on your own. Good luck. And the reality is that you have to fight the Department of Justice and the 200 FBI agents on your own. Now, it even gets worse in certain instances, not all, but in certain instances, where counsel for the company, in an effort to get that deferred prosecution agreement, will do everything possible to have the former management team indicted. Because the reality is that a lot of times prosecutors don't want to work very hard, and they want to get the investigation done by the company and have it turned over on a silver platter. And businesses in America today face enormous consequences if they stand up and they fight the federal government.
Talk about legal fees, John. The companies typically are almost in every state and under bylaws, they're usually required to advance the legal fees of employees. How does that play out in practice?
It's the only way that individuals have the means to defend themselves. And I don't know if there are many general counsel in the audience, but there are ways of ensuring that individuals are protected if you have good insurance, good D&O coverage, indemnification or advancement rights, where if somebody is accused, there's the ability to hire counsel. But the reality is that just to get experts in today's business environment costs tens of millions of dollars. I mean, most of the issues that we're dealing with, the questions are complex, the business concepts are incredibly complicated, and just unraveling the complexity of that costs an enormous amount of money. And if you don't have that support, you get steamrolled.
Now, and the support meaning the legal fees, the fees to pay experts. So you gentlemen, John and Reg, how does the government respond? How has it responded in the past when a company that is ostensibly cooperating with the government and providing evidence against executives and doing everything it possibly can to avoid indictment, get a deferred prosecution agreement, whatever? How do prosecutors take it when that same company is paying the legal fees for the employees that are being investigated?
It depends on the sophistication, I think, of the prosecutors that you're dealing with. And it's not always the case that a company will cut and run on its employees. There was a wonderful result, I think a week or so ago, where Bank of America achieved a really tremendous result at a circuit level where $1 billion verdict against it and against one of its former senior executives was reversed. And the bank stood by the executive, advanced the fees, litigated the matter. Brendan Sullivan and Ken and Chamigan handled that for the bank and did a really tremendous job. And the chamber, thanks Kate, weighed in with an amicus brief in the case. So there are instances where companies will stand with their employees and sort of fight, and the government will kind of see it as an issue of principle and will let it go. But increasingly, there are very aggressive prosecutors who look negatively on people ensuring that folks have the ability to defend themselves. And that is a real issue. I think senior leaders at the Justice Department recognize that there can be overreach, but the incentives are all wrong. The incentives are all wrong within the Justice Department. If you are a prosecutor and you want to make your mark, you bring one of these cases and you get a scalp and you put it up on the wall and then you go cash out. There's got to be some pushback to that kind of behavior on the part of prosecutors.
By the way, that Bank of America case, which just to plug my former law firm, Williams and Connolly, Brendan Sullivan handled it. It was a victory in the circuit, wonderful win in the Second Circuit, basically holding that the violation of a contract, a breach of a contract, even an intentional breach, is not fraud. But think of what it cost the Bank of America to get there. The company went to trial in front of Judge Rakoff in the Southern District of New York. It lost. It suffered a huge judgment of over $1 billion. And then only after all that, it gets to the Second Circuit and prevails. How many companies are willing to run that kind of risk, to take that kind of chance, to stand up like that, when I'm assuming there were opportunities along the way to take some sort of a deal with the government, pay half a billion dollars, a relatively small sum, and get out of the thing. It's the rare company, and again, that's why the PG&E and FedEx cases are so significant. It's the rare company that'll run that gauntlet and take the chance on the win that Bank of America got.
In fairness, John, that was a civil case.
Yes.
Where the consequences
$1 billion doesn't feel civil.
Well,
you're right.
A billion here, a billion there. But I mean, it's different when it's a criminal case, and it's different when a company is facing criminal indictment and looking at what happened to Arthur Andersen, and it changes the equation dramatically when the consequences of making a judgment call mean that your company's going to be indicted. For a lot of companies in regulated industry like healthcare or the securities business, just being indicted means you're done. So you don't really have that opportunity to fight it. And frankly, the equation then is skewed where general counsel and the corporate leaders have to make a decision. And I think in almost every case, the decision is made, what do we do have to cooperate and to make sure we're not indicted?
John, Norm Reamer, when he was talking earlier, said that every lawyer in good faith and in the proper exercise of judgment has counseled clients who may have a legitimate defense to take a guilty plea. Have you found yourself in that position?
Yes.
Tell us about that.
It's multifaceted. It involves advising clients who may look at 15 or 20 years in jail, who make a rational decision that they have to reduce that exposure. It takes an incredibly courageous client to fight. It takes courage. And as a defense lawyer, you want to do the right thing for a client and you want to save their life. But ultimately, it's the client's decision. The pressure on an individual in a criminal investigation is incomprehensible. No one can really understand it unless you've gone through it. The force of the federal government, the power of the federal government is incredible, and it's not a fair system. So you have to explain to a client, you're not going to get a fair trial. Everything is going to be skewed against you. Every decision that's made is to crush you, and it's not going to be easy. So the end result is oftentimes, John, as you know, clients make a judgment call that it's in their interest to plead guilty rather than fight.
Yeah, and I can say, I've been in the same shoes, Reg, I imagine you have too, where I can say this, that there is probably nothing more disheartening for a criminal defense lawyer than to have a client who who protests his or her innocence, who has a fighting chance at trial, but who nonetheless seeks your advice on whether to accept a plea from the government for, let's say the client's looking at potentially 20 years. I had a case just a couple of years ago where I had a client who fit the description I've just given. He protested his innocence, he had a valid defense, but had he been convicted, it was a fraud case, the amount of loss was so high that the guidelines were essentially life. This was a man in his 40s. He had a wife, he had a pretty good life, and he was looking at life in prison if he went to trial and got convicted. The prosecutor offered, I forget what it was, 21 months. What advice do you give a client like that? I mean, the right advice from a purist perspective is, well, of course, if you're innocent, you go to trial. You know, that's what justice is for. That's what trials are for, to free the innocent. You think that's the advice I gave that guy? I told him the reality. If you go to trial, you're probably going to get convicted because, as John says, everything's going to be stacked against you. And if you get convicted, you're going to get life in prison. Now, if you want to go down that road, I'm delighted to defend you. But you might want to think carefully about this 21-month deal that'll have you out in roughly a year and back to your wife and back to your life with a felony conviction and some major disabilities, but at least you'll still have your life.
John, I'm listening to this, and I hope later in the day we're going to hear about ideas to kind of fight back. And I know Kate, you and others have been thinking about this a lot. Part of it's financing the litigation when an individual can't do it themselves. And I think the Chamber has done extraordinary work with amicus briefs, but for others, it's companies being willing to advance those legal fees and allowing somebody to go through the trial, get to the appellate courts where hopefully rationality will prevail. Doesn't happen as much as it should, but financing litigation is a part of it. Another part of it is telling the stories. It's the stories that matter. It's the case where somebody couldn't fight. I read about a case here in DC where a guy who worked at a military retirement home tried to solve a blocked toilet problem by rerouting the sewer from one place to another place, and he inadvertently violated the Clean Water Act. And he didn't try to do anything wrong. He'd actually tried to live life on the straight and narrow. He had, I think, 3 siblings who had been killed because of violence before he was even an adult. He had tried to live life on the straight and narrow. Ultimately, was African American, had to plea, and the prosecutor, in his mercy, sentenced him to probation and a $2,500 fine. But then he couldn't get a job because he had a criminal record. He finally got a job, and the probation officer kept showing up at the facility, and people were wondering what was going on. A wonderful person's life was ruined because a prosecutor overreached because he had the power. It wasn't justice. It was an exercise of power. Bringing that man before Congress and having him tell his story, and frankly, asking the prosecutor to show up and explain what they did, might help change hearts and minds, make people think differently in a concrete way about what a mens rea requirement actually means, how it changes the leverage and the dynamics. And so I think that the Chamber could do a real service by pushing others to tell these stories. I'm sure you've got a dozen of them.
I think that's the best thing we can do. I also think judges have a role, a very, very profound role. There's a case now in the 11th Circuit, U.S. v. Clay, where the court can decide an instance where business leaders made reasonable judgments about complex documents. And hopefully the court will decide that if you make a reasonable judgment about ambiguous or complex regulatory provisions, that means you haven't committed a crime. But the reality is that I think the public needs to hear these stories because, for the most part, nobody cares unless it affects you in a very profound way. but listening to the stories about your neighbors or family members, I think that is the best tool of persuasion.
So let me, we have 5 minutes or so, so let me ask each of you very briefly, if you could do one thing, if you could fix one thing, if you could make one change in the system, what would you do? Kate?
Well, before I handed the wand over to Lisa and her shop to get everything they need to get done on the Hill and fix the mens rea piece, I think I would wave it over the federal agencies and really force them, when they're making a change in how the law is going to be applied to folks, to do it upfront through a rulemaking process where stakeholders can participate, and not to be changing the rules of the road through guidance, informal letters tossed about, and through the enforcement mechanism.
Rich?
Frankly, I would have every U.S. attorney summoned in to speak with the Attorney General and have the Attorney General tell them that their job is to do justice, it's not to win. Because I think that's been lost. I would do the same thing with the federal enforcement agencies writ large, because I think there is a mindset now of we're going to try to win at every cost as opposed to doing justice. That's not in every case. I think many prosecutors, many enforcement officials want to do the right thing, but too many people now want to win, and they're also listening to the political pressure to bring them heads on platters. And I think someone's got to exercise leadership at very senior levels to say, that's not our job, that's not our role.
Mm-hmm. John Laurel?
I would have every politician spend one day with me talking to a client who can't even understand why they're on the other side of a criminal investigation, and walk through the consequences of the existing laws that we have right now.
Well, I think if I could fix one thing, there's so many, but this will sound very concrete, but it actually has a huge impact. I would eliminate the judge-made doctrine of willful blindness. I don't know how many of you deal with willful blindness on a daily basis, but I do. And essentially, most of the time, to commit a crime, you have to know certain facts. Sometimes you have to know what you're doing is illegal, but always you have to know certain facts about what you're doing. But judges, because that's often hard to prove, judges have made up the notion of willful blindness, where if you are aware of, if you're suspicious, if you have reason to know the fact and you choose not to learn it, you fail to investigate. Judges have said that's the equivalent of knowledge. And the result of willful blindness is that prosecutors get the minimal mens rea requirement that already exists is further watered down to the point of essentially negligence. And when you have the typical white collar case where maybe somebody has made money, you've got maybe a prosperous defendant, you have jurors sitting there thinking that that's a person who is sort of inherently suspicious and culpable. And then you have the judge tell the jury that they don't really have to find knowledge at all. Essentially, negligence is enough. You might as well just have the judge direct a verdict of guilt. So this is a very incremental sort of focus change, but I would wipe out the doctrine of willful blindness. All right, we have about a minute, and we're probably over our time anyway, but I'm happy to entertain a few questions if anybody would care to ask one.
Yeah, my name is Dick Beckler. I want to applaud all of you. I agree with everything you said. I think it's true over-criminalization. I won't go through it again, but I will say this. One of the things you did not talk about is probably the most venal part of the system is the, quote, special prosecutor. In every one of the cases you named, be it Arthur Anderson with the Enron task force, BP with the explosion task force, banks with the bank task force, going way back to Iran-Contra, John and I first met each other, special prosecutor. When there is a special prosecutor, even though he may be part of the Justice Department, there is no attempt to even determine who's guilty or who's not. They have one thing in mind and one thing only. That is to accuse someone, and hopefully you can get an individual as well as a company. That's what happened in the BP case. I was involved in that, representing Halliburton as a criminal, on the criminal side of the case. Every time it goes on, over and over and over. They don't care less. And the problem with counsel's suggestion about having senior people lecture the young people or the younger attorneys about doing justice, that's said in every closing argument by every criminal defense lawyer. Let's have justice done here. It's said by the President of the United States. But the bottom line is, if the Attorney General of the United States or the President of the United States says, we want to do something about the environment, and we're going to have this task force that's going to go after BP, that's their mandate. And the gentleman that's going to be on the panel, I'll just close on this later today, he's a classic example how he was mistreated in that prosecution down in New Orleans. Halliburton had an employee who had to plead guilty to a misdemeanor for doing some experiments that nobody even knew about. Why? Because he could not afford his whole life to go to trial. It all starts with a special task force. That's not to say that DOJ and U.S. Attorney's offices around the country don't do the same thing. They do it all the time. But you put that task force in there, it changes the whole game, and we all know that. I just want to make that point, but I appreciate all you've said.
We have 49 seconds.
Thank you. Eric Sterling from the Criminal Justice Policy Foundation. I think a key feature in understanding the rise of over-criminalization was the panic that existed in the 1980s and the haste with which Congress acted. The Comprehensive Crime Control Act of 1984, House floor consideration was 10 minutes on a motion to recommit an amendment to an appropriations bill. Anti-Drug Abuse Act of 1986, which laid the foundation for lots of the mandatory sentences that got carried forward then into the guidelines and affected all the guideline sentences, passed very quickly after the death of Len Bias 30 years ago. So I think a key issue that sort of people need to understand is that many of these provisions are not provisions of law that were carefully considered by Congress, but were considered in haste and in panic. And I think understanding that they shouldn't be given the same kind of weight for the deliberation that other laws might have is a feature in sort of our critique. Thank you.
Well, a classic example of that is the honor services statute. It was the fix for McNally. Judges made up the notion of honest services, and then the Supreme Court in McNally in 1987 said, you can't do that. So Congress passes a statute creating an honest services crime. There's no legislative history. I mean, there was essentially no discussion of it. It was just done without a lot of thought. And until the Skilling case, when the Supreme Court again cut back on it, it was essentially the same as what had gone before. All right, any other questions, comments, thoughts? Great, we're done. Thank you very much.